Now, case study 2 will then take us on to look at trust structures that have underlying companies and have included what's called the Bartlett clause. And we'll look at the Zhong case. That is the case in Hong Kong that was decided late last year. And we'll look at the compatibility of a Bartlett provision with respect to modern AML provisions as they apply to trust company service providers. Looking at case study 2, and the other case studies that follow this are a little bit more, are quicker. They're not as involved. This is quite draggy because it's a big area for everyone to deal with. So case study 2, the basic fact pattern is the same. We have investments. However, the difference with this one is we interpose a company. So this is the traditional company, trust company and account scenario. And the question being asked here is the relationship between the trustee and the underlying company and its liability exposures if that company invests in an unwise way and ends up with losses to the fund. And this is a typical structural scenario. We do have what's called the Bartlett clause, which goes back many, many decades, that tries to separate the trustee's obligation to monitor and then get involved with the underlying company. And we have the Zhong decision, which is the DBS case in Hong Kong, which decided the sort of, well, the main issue here was a long protracted, went through a number of appeals. And the question for us all is, what is the current position with respect to a Bartlett clause under a trust deed? So I'll just explain. Bartlett clause, as I mentioned earlier, is just a provision that allows the trustees to take a standoff approach and not interfere in the underlying companies. It's a bit like a sort of expressly drafted VISTA provision, where the trustee is not permitted to get involved in the day-to-day operations of the company. They don't need to unless they're under express notice of misconduct, fraudulent misconduct at the company level. But otherwise, they are not under an obligation to supervise the company. And that was the whole contention in the Hong Kong case. So what I'd asked Vigna, what's the current position following that case with respect to the validity of Bartlett clauses for the benefits of the attendees that have not been following this?
Sure. So just to give, to add on to your overview, right? It all started with the decision in Bartlett and Barclays, where it's held that where trust holds, controlling block of shares in a company, the trustee has a consequent duty to take action where the affairs of the company are not being conducted appropriately, and use its power to obtain information and make a decision whether to intervene. So as a result of that case, then we had the anti-Bartlett clauses come into play, such as what was drafted in the Chung Hong Lee case. And I think based on the decision in Chung, where the anti-Bartlett clause was upheld, I don't see a reason why it wouldn't be upheld in Singapore.
Mm-hmm. Okay. Going on from that, the one question that would come to mind is this. In the current circumstances where we have these economic fluctuations, can a trustee rely on a Bartlett provision where they supervise and intervene in the activities of the underlying company, notwithstanding the Bartlett provision saying that they don't have to, that they're not obliged to? What is the position? Because when I read that decision, in the Hong Kong decision, they found actually that the trustee wasn't exercising any supervisory role as a matter of fact. So they didn't have to decide that particular point of, I have a Bartlett provision on one hand, but I still intervene anyway, because let's say there's family politics that forces me as a trustee to take a direct hand in what's going on. What is the position if we have a Singapore trustee that finds itself in a position where it has a Bartlett provision, but it actually ends up crossing the line and starts actively supervising the activities of the underlying company? Does that Singapore trustee then take on obligations, or can it effectively sit behind the Bartlett wall if things go wrong? What's the consensus here? And I'd ask Woon Han, what do you make of that?
Okay, so in such a situation, if we were advising the professional trustee and there is a SPV interposed between the trust and the underlying assets and the family enterprises, this is the clear wishes of the settlor. The trust deed should have been properly drafted with the protection provision that says that the trustee does not need to supervise and does not intervene with the affairs of the SPV and what's beneath, especially if the SPV are staffed by directors who are not from the trustee or the affiliates of the trustee. So that's point number one. So point number two is, if that's the case, my position would be similar to when we talk about the reserve powers for the settlor. You leave the SPV signatories and the directors to do what they have to do. But I like what Tony says. They still monitor. So that we would advise the trustees to still monitor and cast an eye and ask the right question from time to time. And then if you smell something, you feel something is wrong, please ask more questions, please ask for more reports. If you feel that there's something going on like dishonesty or fraud, you do have to put a stop to it. You may have to make a report to the authorities, and you do have to put a stop to it to protect the beneficiaries. That would be my short advice.
Right. So again, I'll just restate. So in a case where a trustee does get involved in that way, they could be, by virtue of taking overt actions on the company, they could effectively be waiving the Bartlett protection at that point. Do we agree with that? Victor, I think if you could jump in.
You know, if we read the decision of both the Court of Appeal and the final Court of Appeal in Zhong Li, a lot of attention was placed on the fact that post-execution of the trades, the trustee would still review them and acknowledge them, right, by actually, just signing off. And initially that was held to be proof that some sort of actual supervisory power was being exercised, despite there being an anti-Bartlett clause. I think you're spot on, right, Zach, where despite what the clause says, if in practice you are taking a more active part in the business than provided for in any anti-Bartlett clause, you may then see yourself being exposed to certain liabilities which may have otherwise been excluded by the anti-Bartlett clause.
Okay, I think in the interest of time, let's move on to one other aspect of this, which is the use of Bartlett provisions. Basically, they're quite dated in terms of their use. And generally the view is that you can disconnect from an underlying company, except where you become expressly on notice that something's going wrong. The question I would ask is this actually compatible with modern AML requirements, both at MAS notice level as well as FATF TCSP guidance? So is it really practical for a trustee, a professional trustee, a licensed trustee, to effectively disconnect from the underlying and not seek to effectively understand what they're doing from time to time? How would that actually work within a FATF environment where you should be aware of what's going on within the structure? And I'd invite Lin Chuan, what's your view on this? Is it compatible, the Bartlett provision and disconnecting from the underlying company, and the modern FATF approach for TCSPs, which is you ought to be aware of what's going on within your structures? Sorry, I don't think we can hear you, Lin Chuan.
Yeah, part of the purpose of these notices is to do, customer due diligence on beneficiaries and ultimate benefit. I mean, I think that part's not really relevant to this present discussion. It's the bit, is to sort of monitor your structure and to understand your structure. You understand your business relationship, with your various other stakeholders that might be triggered by this, right? And the purpose of that understanding is limited, and is limited to asking yourself whether or not there are red flags for money laundering. Right? It's not focused on whether it's doing well or poorly as an investment. So there might be some information that comes through financial statements which might otherwise not. But I tend to think it's it is not a very deep interaction in my mind. Others may have a different view, but the question which is more interesting in this space to me is kind of how far do you have to go at all, purely from the AML perspective, in understanding and understanding to test whether there's an AML risk there. That's a different more difficult question. I think on the whether that means that you have some degree of investment supervision, I think the link is fairly weak in my mind.
Tony, from a trustee perspective, do you sort of look and see what the companies are actually doing as part of your compliance culture? Or how does it work for the balance between being able to rely on a Bartlett and at the same time comply with your AML requirements?
Yes, I mean, I think the anti-Bartlett ones, I mean, they're really there to protect the trustees. I don't think it should undermine the proper administration of a trust. And AML requirements falls within that. So I think if you're aware of what's under there, you know what the entity owns, what people are doing. I think it's different to actually getting involved and interfering,
Right.
which then leads to the next stage that we were talking about earlier in terms of undermining the effectiveness of those clauses.
Right.
I think if you hid behind the I need the protection of the anti-Bartlett clauses, therefore I'm not going to look underneath, I think you're going to fall short of the MAS notice and the FATF guidance.
Right. Okay.